All right, let's begin then, and we'll bring our cast of characters in at this point, and we'll start the prosecutor's half of the case. And here we go.
Yeah, okay.
All rise, please. You may be seated.
All right, gentlemen, this is the time and place set certain for a court trial of Mr. Powell. Your name is Charles Powell, is that correct?
That's right.
And the state of Idaho is represented by?
Robert Hallstrom, Your Honor.
Okay, Mr. Hallstrom, you're representing the state of Idaho in this matter. Mr. Powell, you've been charged with violating the basic speed rule, that is, driving 55 miles an hour in a 35 mile an hour zone. You've been charged with plain speeding. That's 2 counts of speeding in violation of Idaho Code 22-14-101. And this is the time and place set certain for that court trial, which you asked for last March 10th. Are you ready to proceed today, Mr. Powell?
I believe I am, sir.
And is the state ready to proceed, Mr. Hallstrom?
Yes, Your Honor, we're ready to proceed.
Okay. All right, now, Mr. Powell, are you familiar with the rules of procedure in these court matters?
Not really, but I can watch and I think I can get along.
All right. Well, Mr. Powell, I'll help you in every way I can. However, since you're representing yourself, I presume today pro se, is that correct?
That's right.
Okay. Now, if you had an attorney here, the attorney would be held to certain and specified standards that the court sets down and the Bar Association sets down. And I'm going to hold you to the same standards of performance as I would an attorney. Do you understand that?
Yes, Your Honor.
All right. Mr. Hallstrom, would you like to make an opening statement?
Just a brief one, Your Honor. The case before the court is a very simple speeding case. It involves speeding on Fairview Avenue of 55 and a 35, and it's very obvious. We have the policeman here to present the evidence, and the prosecution will show that Mr. Powell, in fact, was speeding on Fairview in violation of Idaho Code 22-14-101, and should be so found guilty.
All right, Mr. Hallstrom. Would you like to make your opening statement now, Mr. Powell, or would you like to reserve that for your half of the case?
I would like to reserve that.
All right, Mr. Powell. Let the record show that Mr. Powell is going to reserve his opening statement, and we're ready now for the state to proceed. The opening statement having been made, let the record so show. Mr. Hallstrom, you may bring your first witness forward.
Thank you, Your Honor. The prosecution calls Officer Coy. Officer Coy, would you please step forward?
Mr. Coy, would you please face the clerk and be sworn?
Do you hereby testify to the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Please be seated, please.
Mr. Coy, if you'll just take the witness chair. Mr. Hallstrom, you may proceed.
Thank you, Your Honor. Officer Coy, what do you do for a living?
I'm a Boise City police officer with the Boise City Police.
I see. And how long have you been on the police force?
For 9 years.
For 9 years. And what is your rank?
I'm just an officer.
Just an officer, okay. That's fine. And you were on duty then the day of 10 March 1983?
Yes, that's right.
And where were you located on that particular day, say about 9 o'clock in the morning?
At 9 in the morning, I was sitting in a parking lot of queues on Fairview Avenue with my radar and heading towards the Fairview Road.
In other words, you were monitoring traffic from that position then?
Yes, that's right.
I see. And did you notice any vehicles doing anything in a abnormal manner?
Yes, I did. At approximately 9:02, I observed a 55 Chevy pickup headed in a westerly direction at a rather high rate of speed. It indicated on my radar at that time that this individual was doing approximately 55 miles per hour in a 35 mile per hour zone.
Then did you give pursuit?
Yes, at that time I pulled out of the parking lot and got behind the individual and set up a sight picture to determine the speed and also check my speed on my speedometer.
In other words, you actually used your speedometer also to verify the speed of the individual.
Yes, that's right.
I see. Did you stop the individual or the vehicle?
Yes, at that time, after making those observations, I did pull the defendant over.
I see. And did you, in fact, cite the defendant?
Yes, I did.
Can you identify that person at this time?
Yes, I can.
Could you point him out to the court, please?
It's the defendant sitting here at the table.
I see. We'll let the record show that the officer has identified the defendant, Mr. Powell, as being the party cited for the offense.
Okay, we'll let the record show that Mr. Powell is wearing a checkered sports jacket and a striped tie, and he's a gentleman sitting to the right of the prosecutor, Mr. Hallstrom, and that the witness has identified Mr. Charles Powell as the defendant.
Okay, in your normal duties then, Officer Coy, is it quite frequently that you have the opportunity to work with the traffic regulations?
Yes, it is.
I see, and therefore you're familiar with Idaho Code 22-114-101, is that correct?
Yes, I am.
And you know for a fact of your own knowledge that that is a speeding law on the statutes of the state of Idaho, is that correct?
Yes, it is.
I see. Was this incident in Fairview, was in the city of Boise, is that correct?
Yes, that's right.
And that's in the county of Ada?
Yes, it is.
Have you ever been in these courts before?
Yes, I have.
I see. In this particular courtroom?
Yes.
Do you know for a fact of your own knowledge that similar offenses are tried in this court?
Yes, they are.
I see. Did you have another officer with you at that time?
Not on that particular day, no.
I see. I think that's no more questions, Your Honor.
Would you like to cross-examine Mr. Powell?
Officer Coy, on that day when you stopped me, you said that you had saw me on radar. You didn't say anything that day about your particular calibrated speed meter. I asked to see that radar gun, and you wouldn't show it to me.
Excuse me, Mr. Powell. These long questions of narration, we can't use that type of testimony or questioning. This is cross-examination, Mr. Powell, and on cross-examination you may examine this witness pursuant to the foundation that has been laid by the prosecutor. You may ask him questions about the speed and the radar, but they have to be answered yes or no. So would you rephrase your question so that Officer Coy can answer that question yes or no?
Okay, Officer Coy, are you fully certain that these radar guns are in fact accurate?
Yes, I am.
Your Honor, the validity of the radar gun wasn't an issue brought forth on direct, and I would move that this type of questioning not be allowed. Okay,
are you making an objection, Mr. Hall?
Yes, Your Honor, I am.
Okay, so your objection then on the record is that there was no foundation for the...
That's correct, Your Honor.
Okay. I'm going to sustain the objection. There's no foundation for that question.
Your Honor, I've heard that these radars are not accurate, and I object to this radar without being shown that. It would have been a witness to me.
Excuse me, Mr. Powell.
Your Honor, the state has no problems with Mr. Powell pursuing that type of line of questioning on his own witnesses and this type of thing. If he has radar experts to bring forward to challenge the validity of the radar, I think we could handle that, but I think it's inappropriate for Officer McCoy.
Okay, I'm going to sustain the objection. Mr. Powell, on cross-examination, you'll limit your questions to the subject matter that's been brought by the state in their direct examination, such as the speed and whether or not the odometer is a factor in the radar you can ask questions about, and whatever the foundation laid by the state happens to be, you may cross-examine. Okay, do you understand that?
Yes, Your Honor, but it seems like then that all these cases you hear about all over the place is just not listened to, so I can't ask you any more questions because I can't get any answers.
Okay. Are you completed now with your cross-examination of Mr. Coy?
Yes, sir.
Okay. Do you have any other witnesses, Mr.
No, I just think, Mr. Coy, would you reiterate for the record that what was the speed again that you indicated that the defendant was traveling?
The speed of the defendant was 55 miles per hour.
I see, and that was on Fairview Avenue, is that correct?
On Fairview Avenue, yes.
And is not Fairview Avenue posted several places at 35 miles an hour?
Yes, approximately every half mile it's posted with a 35 mile per hour speed limit.
I see. Okay, I have no further questions, Your Honor.
Okay. You're completed with your redirect. Okay, you may be excused, Mr. Coy.
Thank you, Your Honor.
Your Honor, the state has no further witnesses, and so we would rest at this time.
Okay. The state rests. Okay, Mr. Powell, would you, do you have any witnesses to present?
No, I don't, Your Honor.
Mr. Powell, are you going to take the stand in your own defense? Did you want to offer any testimony today in this matter?
The only thing is I just didn't think I was doing 55.
Okay. All right. Now, as a matter of procedure, I'm going to ask you one more time. If you want to take the stand in your own defense, you do not have to take the witness stand. You cannot be compelled to take the witness stand. You have constitutional protections under the Fifth Amendment. You do not have to testify against yourself. However, if you do elect to take the witness stand, anything you say can and will be used in this trial against you, and the prosecutor may cross-examine you on any of the subject matter that you testify to. Now, do you want to present any witnesses, or do you want to testify yourself? All right, Mr. Powell, would you step up here and be sworn, please?
The prosecution has no objections if he just remains there, unless the court wishes he can.
I think it would be more appropriate if we had him in the witness chair.
All right, Your Honor.
Would you face the clerk and raise your right hand, Mr. Powell?
Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Can we have a seat, please?
You can sit here, Mr. Powell. Okay, let the record show that Mr. Powell is now in the witness chair and that he is about to testify on his own behalf pursuant to this matter. And Mr. Powell, you may proceed.
Well, that particular morning, I explained to the officer that I was late for work, and I figured I was probably pushing the speed limit just a little bit, but my speed meter didn't read 55. I was only reading about 39.
Okay.
And I have heard, and I even saw on TV one time where these radars are not accurate and that they just don't show things as they really are. And there was a big truck going by me at the time that the policeman observed me, and he was passing me, and he didn't stop him.
Do you have anything further, Mr. Powell?
No, sir, I don't, Your Honor.
All right. Does the state have any questions on cross-examination?
Yes, Your Honor.
All right. Alston, go ahead.
Thank you. Mr. Powell, you said you were late for work. Is that correct?
That's right, sir.
And you live on Fairview somewhere out there in that area, I presume?
Yes.
I see. And you come down that road every morning?
Yes, I do, Your Honor.
Okay. And And this was just another normal morning that you were going to work on your same routine path of getting to work every morning. Is that correct?
Yes, it was, except for being a little late.
Yeah, I see. But then you know that the speed limit up and down Fairview then is 35 miles an hour. Is that correct?
Yes, I do.
I see. And you say that you were pushing the speed a little bit?
Yes, I was.
I see. Then you recognize then that you were exceeding the 35 mile an hour speed limit, be it 39, 49, or 59 miles an hour. Is that correct?
I observed my meter at about 39.
I see. I have no further questions, Your Honor.
Okay. Then let the record show that the state rests and the defense rests. Do you have a closing statement? Mr. Powell, you may take the defendant's chair again. Thank you very much. Would the state like at this time to make its closing argument?
Just a brief one, Your Honor. I recognize the court has a heavy docket. It's very obvious, Your Honor, from the testimony presented today that the case is well established. The officer is an officer on duty with the Boise City Police Department. The offense did occur within the county and within the jurisdiction of this court. And the officer did observe the defendant traveling at a high rate of speed and did clock him on radar and also with his odometer and also with visual observation. He's identified the defendant, and the defendant of his own testimony before the court has said that he was late for work and, in fact, was speeding. And so, therefore, his confession to the crime is also just more evidence of the fact that he was in violation of Idaho Code 22-14101, and I think it's evident the court must find him guilty as charged.
Thank you, Mr. Hallstrom. Mr. Powell, do you have a closing statement?
Well, Your Honor, I still feel that it's wrong that he would pull me over and I pulled that truck over that was passing me at the time that he saw me. And I feel that I shouldn't be held guilty when I was only doing 4 miles an hour over the speed limit. And I know this truck was doing more than that. And I know that I've heard that those trucks do mess up, those big trucks do mess up radar.
Okay, is there anything else you'd like to add, Mr. Powell?
No, it isn't, Your Honor.
Okay. Let the record show that all the testimony is in, that the state has rested and made its closing arguments and statements, and that the defendant, Charles Powell, has made his closing statements, and that the defense has rested, and that the case is now before the court to make a determination of guilt or innocence. And at this time, I would like to run over the factual matters of the case. As a matter of fact, the court finds that you were driving a 1955 Chevrolet pickup eastbound on Fairview Avenue, and that you were, in fact, driving something over the speed limit, that you were, in fact, late for work, and that you made an admission that you were late for work, and that you were traveling at a rate of speed at least 39 miles an hour. The police officer testified that the speed you were traveling was approximately 55 miles an hour. We have a statement of fact that there was a large truck, evidently right alongside you at the time or in a close proximity. The state has not refuted or given any evidence that there was no truck there. Now, as a matter of fact, then, I must find that you're guilty of speeding, because there is no contested issue of fact as to whether or not you were speeding. You admitted that you were speeding, and the police officer testified that you were speeding. So as a conclusion of law, I must find you guilty. Now, the culpability of the event comes into play. That is, just how culpable were you in the event? And I'm going to find that your culpability is great, because there is no contested issue of fact that you traveled on that street often. In fact, I believe you testified every day, or nearly every day, and that you had seen the traffic signs that regulate speed at 35 miles an hour, so you know what the speed limit is. And since you not only know what the speed limit is, you know what the speed limit is on that street because you travel on it daily. On cross-examination, you stated that you were late to work, which adds to the culpability because you simply admitted that you needed the speed, and that seems to be your excuse. I needed the speed because I was late for work. Your defense that the truck should also be pulled over is not supported by the state of the law in Idaho or in any other state, to my knowledge. The police officer, if he witnesses 3 crimes being committed simultaneously, may only be able to apprehend one of the criminals. But that doesn't mean that because the other 2 persons are not apprehended, that in some way exonerates you from your guilt. So it's for that reason that I find you guilty of speeding. The penalty for speeding is a maximum $300 fine and a possible 6 months in jail. Now, I've taken the liberty to look into your past driving record, and I find that you have 6 speeding violations in the last 3 years. So this thing of speeding is not something new. And 55 miles an hour in a 35 mile an hour zone is an excessive rate of speed of such magnitude that, based upon your prior record, I think that the court is going to have to take some special notice of your particular behavior. Now, Mr. Powell, as a matter of law, you have a right to be sentenced 24 hours after the entry of a guilty conviction. The date is July 13th, 1983, and I'm going to enter that guilty conviction against you today. Would you like to waive time for the imposition of sentence, or would you like to come back at least 24 hours from now, which would be tomorrow? I could set sentencing, or I could set it on Monday, July 18th. Which would you prefer?
You mean to set sentencing tomorrow or on Monday?
Or you can waive the sentencing right, and I can impose sentence upon you today.
I guess I just as well waive the right.
I think that's a good idea. There's no sense in tying up the court.
All right, Mr. Powell, let the record show then that Mr. Powell has waived his right to time on sentencing, and I'm going to, at this time, impose sentence. Mr. Powell, would you rise and face the court, please? Mr. Powell, after having been found guilty of speeding, I'm going to impose sentence of $150 and 30 days in the county jail, and I'm going to suspend 20 of the 30 days. Let me ask you a question, Mr. Powell. Do you know of any lawful reason why I cannot impose this sentence upon you?
No, I don't know.
Okay. And Mr. Powell, do you have a driver's license?
Yes, I do.
Okay. And I'm going to suspend your driving privilege for 30 days. And sentence will begin. Let me ask you this. Are there any mitigating circumstances that you'd like the court to be aware of prior to executing the sentence?
I would just like to have a chance to try to get an emergency vacation from my job.
Okay, and how long will that take, Mr. Powell?
Probably should take a couple hours.
All right. Then I'll just order you to report to the Ada County Jail at 5 o'clock tonight on the 13th day of July to serve your 10-day sentence. And I'm going to also impose 1 year probation on this charge. And if you're caught speeding again during the 1 year probation, you will automatically be taken in to serve the other 20 days of your sentence. Do you understand that, Mr. Powell?
Yes.
Okay, now on the $150 fine, there's $11.50 court costs for a total of $161.50. Can you take care of that today, Mr. Powell?
Yes, I can do that.
Okay. Then I want you to take these tickets out to the...
Your Honor, I'd like to clarify one thing for the record, if I may, please.
All right, go ahead, Mr.
You indicated that there was a 30-day suspended driver's license privilege during here and also 10 days in jail.
Yes.
The 30-day suspended driving privilege start at the end of the jail time, or is it going to run simultaneous with the jail time?
Well, that's a good point, Mr. Hallstrom. Yes, the 30 days will begin at the conclusion of your 10 days in jail, so we'll start that 30-day suspension on July 23rd, 1983 to run until August 23rd, 1983.
I'd like the county sheriff or somebody to hold his license or in some manner tour the court.
Okay. Well, you won't need your license while you're in jail, Mr. Powell, so the court will hold your license, and I'll take that today. You can give that to the clerk, and you may go out and pay the $161.50 to the clerk and report to the county jail at 5 o'clock tonight. All right? This case is...
Your Honor, would you advise the defendant that if he doesn't show up that he could possibly be held in contempt of court so that he would know the ramifications of that?
Mr. Powell, do you understand that if you fail to show up at 5 o'clock, an additional charge of contempt of court may be imposed upon you? Do you understand that?
I understand.
All right, Mr. Powell. This case is closed. Next case.
Now, that's fun, isn't it, George?
Well, I'll say it was fun. We just laid another guy away, didn't we?
Did you get the money?
Well, they'll collect it right out there.
Oh, okay. They won't get away from us, huh?
Another $161 in the county's coffers.
Gee, that's wonderful. How does it feel to be the Honorable G.G. Gordon presiding?
Well, I really feel a little guilty there, Bob.
You do?
Yeah. I like to sit over here on this side so that I can play with the judges like a cat plays with a mouse.
Yeah, this is just the way it comes down in the courtroom, too, isn't it?
What you just saw here on this particular trial is typical of what happens here in Ada County, Idaho. Now, I don't know about you in Illinois or Maine or Michigan or New Hampshire or Texas or wherever you're from, and I'll just assume that you have some form of typical kangaroo court and the typical angry or in some cases passive citizen who goes into the courtroom and says, hey, this isn't right. There's this big truck driving along, and gosh, I was maybe speeding a little, but I wasn't going that fast. And I recognize that the police oftentimes give a guy a ticket for 4 miles an hour over the speed limit, and he's just sitting there saying, well, this just doesn't make sense, and it just isn't right, and it maybe isn't right, but as a matter of law, what you saw here and what the judge would do is find as a matter of fact that you're guilty. What do you think a guy should do, Bob? Now, you played the part of the prosecutor here. What could Mr. Powell have done to have eliminated this case or to have won this case?
I don't think he could have done anything. I thought he was pretty dumb, didn't you?
Well, let's assume that he knew a little something. I noticed while I was sitting over there, Bob, there were 2 or 3 issues of the prima facie case that you had failed to prove.
Well, you can't ever establish any evidence in these traffic courts because there is no evidence. I mean, what evidence do you have? You've got nothing but the testimony of an officer, and that's it. And so, therefore, you have a one-on-one situation and what we refer to as a contested issue of fact. But that's the way it works in that traffic court.
So as a contested issue of fact, then, here's what would have happened. Well, let's suppose that Mr. Powell had taken the stand and said, I was driving east on Fairview at 34 miles an hour, and I was not traveling at 55 miles an hour, and there was a truck right alongside my car, and it's a well-established fact that when radar is used, it picks up the biggest object, and the truck was passing me. And the truck was going over 35 miles an hour. Now, what do you think would have happened then, Bob?
Well, we'd have found him guilty anyhow.
Well, we would have established a reversible error issue, wouldn't we?
Oh, well, yeah, he would have done that, but nothing would have changed. The script would have come down the same.
There's a good possibility that typical, ordinary, everyday garden variety judge would go ahead and find him guilty anyway just to collect the money.
Absolutely.
And maybe make a bargain day out of it. Instead of giving him 30 days in jail and a $150 fine, maybe, well, I'm going to make this $30 fine or something on that order.
Yeah.
All right, now, I want you to notice that there were 6 issues of the prima facie case that needed to be proved. Now, the prosecutor, Mr. Hallstrom, failed to prove 3 of these issues. Now, remember that the prima facie case in some cases could have as many as 10, 20, or 30 particular indicia that must be demonstrated, proved with evidence or testimony, but there are 6 basic indicia that have to be proven in every case, and they are: number 1, there must be a law written somewhere that commands or forbids some act. It may be a city ordinance, county ordinance, state or federal statute, regulation, or state or federal constitution. In this case, the statute was Title 22, and I forgot the exact
14101.
14101.
Your Honor.
No, thank you, Mr. Hallstrom.
That's quite right.
And the prosecutor did, in fact, identify the particular statute and claim that the defendant broke or violated that law. Number 2, there must be jurisdiction over your person, geography, and the subject matter. Now, in this particular case, the prosecutor never asserted or proved jurisdiction.
Now, wait a minute. Didn't we establish that this was in the Ada County and that the man lived in Ada County? He resided somewhere around Fairview. Out of his own mouth, he said that. Didn't we understand that the policeman was a Boise City policeman, and this was Ada County, and this was the court where he was, in fact, where all these type of prosecutions were held?
Well, if the defendant had brought up the subject of jurisdiction, it was not shown that it was within the jurisdiction of the court, the county of Ada, and the city of Boise. It was assumed by everyone in here that he was within the jurisdiction.
Well, it's always assumed to be within the jurisdiction. Would I take out a traffic case before the district court?
Well, if the defendant in this case had challenged jurisdiction and challenged your prima facie case with an objection timely, he could have had this either dismissed here, or he would have had a good appealable issue.
Yeah, that's right. I agree with you.
So he missed item number 2. The jurisdiction was not challenged, nor did the state assert and prove it. Now, number 3, there must be positive identification of the criminal. Now, there was positive identification by Officer Coy, who identified the defendant as the man that he gave the ticket to back there in February, I believe. There must be eyewitnesses, and this requirement is spelled out by statute in Idaho in all misdemeanors. You must keep in mind that in a misdemeanor, there has to be an eyewitness. Oftentimes, police will give tickets, make arrests, when they themselves were not the eyewitnesses, and these are especially poignant when we take a look at disturbing the peace. And no one saw anybody disturb the peace. They just heard loud music or noise or yelling, and they'll come over to a house and they will make some kind of an arrest or some kind of a charge, when in fact there are no eyewitnesses. And there's oftentimes a good place, on item 4 on the prima facie issue, to get a dismissal. And then item number 5, there must be evidence that would lead a reasonably prudent person to believe that a crime has been committed and that the accused is the guilty party. In this particular case, the prosecutor, Mr. Hallstrom, produced not one shred of any tangible evidence to show that this man was guilty.
What evidence could I show?
A radar printout.
They don't do that. They just got little flashy colors things there that the officer can see, and he punches a button and goes right away.
How about an affidavit from the police officer?
Josh, I had his testimony.
Corresponding testimony: at the mouth of 2 witnesses shall a man be condemned. Where was the second witness?
I guess he was a truck driver that we didn't catch.
Okay, and then Mr. Powell never made any objection to the proceedings against him.
No.
And so, therefore, we must presume that he agreed with the prosecutor's position in the case. And in item 6, guilty beyond a reasonable doubt in a criminal case is the minimum standard for conviction. I'm convinced that he was guilty beyond a reasonable doubt because out of his own mouth he admitted that he was speeding.
Yeah.
The only issue was he speeding 4 miles an hour over the speed limit or 20 miles an hour over the speed limit? That being the case, we knew he was guilty. We just didn't know the degree of guilt, did we? Now, that being the case, what you saw here was a man, in effect, convict himself. He summoned himself into the traffic court by signing the ticket. He had a driver's license, and so therefore it was obvious that we had jurisdiction in the matter. And then he came in and confessed that he was speeding. He did not put up a viable defense for himself. He was unable to cross-examine with any kind or any degree of ability or talent. Had he taken the stand and said, "No, I was traveling at 35 miles an hour, not a mile over," had he gotten the policeman on the stand and said, "Isn't it a fact, officer, that there was a 18-wheel truck next to me?" He probably would have said, "Yeah." "And isn't it a fact, officer, that the truck was overtaking my pickup?" He may have gotten that admission, or he may not have. If he didn't get that admission, he could have testified to it, which would have made the contested issue of fact expand, and then the preponderance of evidence, and then reasonable doubt would have been established in the court's mind because of these direct statements. There was a truck there. The truck was going faster than the pickup. The pickup was going 35. The radar picked the truck up at going 55. In other words, it would have told a reasonably prudent person that probably the defendant was correct.
Mm-hmm. Yeah, I think the important thing that you should gain from this particular little scenario is the lack of the ability of the prosecutor, and how the judge takes over the scene, which is typical, and how the defendant normally is just upset and mad at the system. And the prosecution's half, especially in these traffic courts, amounts to a hill of beans. They may or may not establish the jurisdiction. They may not do anything. They just may go in there and call a witness, and that's the end of it, and just like you saw a little scenario here. And I think it's important for you people out there to make a checklist of things that have to be done. And we gave you the prima facie case, and you should have that checklist set in there, so when that prosecutor is presenting his half of the case, and you check them off. Did he or did he not establish the jurisdiction, geography, subject matter, and et cetera, and et cetera? And if he didn't check one of those off, then you need to be able to challenge that at the end when the prosecution rests. And if you don't have your check sheet, you won't know how to do that. So you should get that prima facie case information out and write it down and use it. Because the prosecuting attorneys typically, especially in your lower courts, are just dumb and ignorant. Like Berger said, 90% of them are incompetent or something like that?
90% was the number I heard.
Yeah. Now, if you get into your other bigger cases, when they start getting up into your felony charges and this type of thing, they get a little bit smarter, and they'll start establishing jurisdiction and doing the right things. But you still ought to have your check sheet out and make sure that they do that, because if you don't object timely...
Failure to object timely is fatal.
That's right. And they'll assume that you've waived your rights. Isn't that correct?
Absolutely. Now, there was one other thing that I noticed here, was that Mr. Powell did not have a checklist of questions to ask the officer. When he walked in, he should have had his yellow pad with probably 30 or 40 questions, and some of the questions would have been foundational questions. Now, you say you were parked in Q's parking lot. Yes, I was. And you say that you had your radar on. Yes, I did. And let me ask you this, officer. What's the make and model of the radar unit that you use? Well, it's called the, what is it, the Gippler or Gappler or whatever it is?
Doppler. Who cares?
Whatever. And who's the manufacturer of it? Well, it's Westinghouse. And when was it manufactured, or how old a unit is it? Well, I don't know, or it's 5 years old. And is this a portable unit or is it a stationary unit? Well, it's a portable unit. And where did you go to school, and where were you trained to use that unit, and how accurate is it, and
do you have an FCC license to use it?
And do you have an FCC license to use it? In other words, from the driver's license, not the driver's license book, but the radar book, isn't there about 100 questions?
Yeah, I think there's 150 questions in our driver's radar, that radar book, to ask that are basic questions about the radar issue.
Another thing you'll notice, that this entire scenario in a court trial took about 20 minutes maybe, max.
20, 30 minutes.
Doesn't cost the court any money, but even in a court trial, 150 questions of that police officer would send a strong message to the policeman. If you had 20 people, in your city or your county doing this, and we had a jury trial, and it was to take a day or a day and a half, and 150 questions of the officer. What about some expert witnesses? Do you have a radar technician who's maybe a veteran of the Air Force who knows something about radar that you could bring in as an expert witness to repudiate the Westinghouse machine, the Doppler system of radar, I'm not very knowledgeable on radar, Bob, personally, but there's a number of expert witness questions that need to be brought out. And our book on the radar issue would tie this court up and make them spend $1,500. Even if they fined you $300 and 6 months in jail, it wouldn't be profitable for them, would it?
No, because it's going to cost them an awful lot of money to house and feed you out there.
Now, another thing you'll notice that Mr. Powell didn't have any motions, briefs, or arguments that he had in his pretrial folder which would give him appealable issues. I asked him, do you know of any lawful reason why I cannot impose sentence upon you? And he said no.
Yeah, that's right. He just gave you the license to go ahead and do it, right?
Actually, there's about 5 reasons why we could not impose sentence upon him today. In other words, even though we found him guilty, there were a number of reasons. The counsel issue was number one. He was here by himself and never once raised the counsel issue.
No.
He didn't demand a jury trial, so we tried him here. I asked him if he knew of any lawful reason why I couldn't pass sentence. I happen to know of 5 reasons why I couldn't pass sentence, and that's why I asked him for his permission to pass sentence. So I think what we need to do now, Bob, is to put you over here in the defendant's chair, put you on the hot seat, charge you with the same crime, and let's see whether or not you can defend yourself. You think you can?
No.
You want to give it a shot?
Well, let's see what comes down.
All right. Let's try this case over again. A simple court trial, but this time, let's do it with a competent pro se litigant, and let's see whether or not a competent pro se can raise some major federal questions and raise some procedural objections in this trial.